Good afternoon, ladies. Welcome to our Coffee with CMM seminar number 23, and it's a ladies only session. So, we are very happy, pleased to welcome you to our seminar, and thank you for agreeing to give a talk
Of course, no
from
problem.
our group, Creative Minds Media, aka CMM, and you're Georgia Cantos, and you've got your colleague with you, Lauren. So thank you, very welcome. So today's the topic is will writing, and I understand that you're from Hugh Jones Solicitors,
Yes.
and you specialize in will writing.
Yeah, so we're specialists in court protection matters and private client law. So within private client law, we do will writing, and we also put in place lasting power of attorney, and we do probate as well. So when somebody's passed away, we help administer their estate. Court of protection is more focused when people lose mental capacity. So it's when the court steps in to help them manage their financial affairs and their health and welfare as well. But we mainly specialise with financial affairs. But I am a private client lawyer, so I do specialise in will writing.
That's excellent. Thank you. A normal misconception is that you do not need a solicitor, especially in our community. They think that they can just write the will and then the will be executed after they've departed. But what do you think? Is it important or is it compulsory to have a will done by the solicitor?
It's not compulsory to have it done by a solicitor, but there are very specific requirements for a will to be legally binding. So in order for a will to be legally binding, it has to have the right drafting, so it has to have the right wording, which obviously a solicitor would be able to advise on, but it also needs to be executed in a very specific way. So when you sign the will, you have to do that in the presence of two independent witnesses. Although it's something that you can draft up yourself, I always recommend getting a solicitor involved, because if anything was to ever go wrong, so if there was slightly, if the will could be read in an incorrect way, then there's nobody there to back up what you intended, basically. And there's also an insurance sort of back, the insurance is important as well. A solicitor is insured, so if anything ever goes wrong, you've got that backup as well financially.
Perfect. That's great. Can I just ask? So, can a will cover both money and personal belongings as well?
Absolutely.
Like
So,
we have lots of jewelry and stuff. So, how do we divide that? So, do
of
we need to
course,
write down each and every article?
absolutely. Yeah. So you can specify exactly what personal items you want to go to specific people. You can also do a clause in a will, which we often do, which is a sort of a flexible clause, which allows you to write a separate letter of wishes, which details every single item. Because often you obtain more personal items as you grow older. So you can write it down in a separate letter, which is kept alongside your will. Although it's not legally binding, it's very morally binding. So if once somebody's reading your will, they'll be able to see, actually, they want this piece of jewellery to go to this person. But if you want it to be legally binding, it can be put in your will.
Excellent. So I have just one last question for you, and then I'll let you carry on with the session. And then I've got lovely ladies; they'll be asking you millions of questions. And so, just one thing is that is there a period of time that the will is valid for?
So that once you write a will, it's valid for the rest of your life. But obviously, if your circumstances change, it can mean that parts of your will are no longer valid. So if, for example, if you leave a gift to a specific person that passes away, that gift is now redundant. And what often happens if you don't redo your will is that it goes by what we call the law of intestacy, which I'll touch on in my presentation. But it's the UK laws which guide exactly how your assets pass. So we always recommend, if you're doing a will, you want to review it, particularly if your circumstances change, but also just generally every 10 years or so.
That's great. Thank you so much.
No problem.
And I look forward to the session now. Over to you.
Lovely, thank you. Which sets out your wishes and what you want to happen to your assets when you pass away. So this includes things like your bank accounts, your personal items like we talked about before, so jewellery and anything else that you have in your home, and your house as well, of course. As we said before, although you can prepare a will yourself, there are very strict legal requirements, and if you don't meet those legal requirements, then it's not a valid will, and it just won't work. For example, it has to be drafted in a particular way, and you also have to make sure that it's signed from 2 independent witnesses. Those witnesses cannot be linked or related to anybody that's in the will at all. We always recommend that you go through a solicitor because they're regulated, so they're basically constantly checked up on to make sure that they know what they're doing. And also, as I said before, they've got insurances. Things can become so expensive if you don't have, if things are done incorrectly. And you always have the backup of a solicitor's insurance if anything's ever done incorrectly, basically. So, it's estimated that in the UK there are 59% of adults don't have a will.
Yeah.
So, 38% of them say that they think, oh, I don't have anything that's worth inheriting, so I'm not going to bother putting in place a will. Then 20% of people say that they've just never considered making a will, and 16% of people say that they're too busy to make a will, which I think we can all be a bit guilty of, but it's a really important thing to do. So ultimately I'm going to discuss the importance of making a will and go through some of the complexities around it. So the main reason, well, one of the main reasons to make a will is to avoid any conflict or disputes when somebody passes away. Ultimately, it's a really difficult time for your family if somebody passes away, and often that means that emotions getting heightened, so people are particularly likely to argue about things. In your will, you can also address other things, so you can address, as we said, giving gifts of items, but you can also put in place your funeral wishes. Although it's not legally binding in a will, it clearly sets out what you want to take place when you pass away at your funeral. And you can also put in place somebody called an executor. An executor is somebody that you trust to basically administer your estate, so arrange a funeral, pay off any debts if you have any, and making sure the items and the money go to the right people. If you don't have an executor in place, it usually falls to the next of kin. Sometimes people have next of kin that they think, oh, I don't know if I could, trust them to do something like that. So it's important to make sure that you have somebody that you trust in place as your executor. So ultimately, it just prevents confusion and it sets everything out in black and white. So what are the benefits of making a will? As I said, you can be clear about who gets your assets. You can keep your assets out of the hands of people that you don't want them to go to. You can also do some care fee planning. Nobody really envisions going into care. Sometimes putting in place a will with certain sort of clauses and drafting, it can mean that you help protect some of your assets so that they don't get completely exhausted by care fees. I'm sure we've all heard sort of horror stories where people go into care, then they have to sell the family home, and then all of their assets just get run down and they end up with nothing to pass on. There are certain ways of protecting against that, but if you do want to do something like that, you have to get a solicitor involved. You just have to. So you can also plan for other family members. One of the things that at Hugh Jones we're sort of specialists in is when family members or people have children that are disabled, or they have dependents that require additional sort of help as they grow older. There are certain types of wills that you can put in place to ensure that people retain them access to benefits if they're on benefits, and also that the money is protected if they have a child which is disabled and unable to manage that money themselves. With larger estates, a will can be used as a way of planning for inheritance tax as well. So we'll go through a couple of bits later on. So if you don't make a will, as I said before, because 59% of people in the UK haven't made a will, I think it's firstly quite important to dispel a few myths about what happens to your assets if you don't make a will. So firstly, your money will not go to the government if you don't make a will. It goes by the rules of intestacy, which I'll touch on later on. But one of the other things that I come across a lot is people say, that there's such a thing as common law marriage. So when people perhaps live together for a long period of time, and they think that counts as marriage in the eyes of the law in the UK, it absolutely doesn't. So you can live with somebody for tens and tens of years, and then if you pass away, they will have no entitlement to anything that you've ever owned. So that's a big myth that we come across a lot as well. So this is exactly what would happen. So Farzana asked me to just touch on Sharia law and wills. I'm not a specialist in Sharia law writing wills, but I can tell you that if you pass away without a will in the UK, it won't go by Sharia law. It will go by UK law, English law specifically. So if you want a will and you want your assets to pass in line with Sharia law, you need to speak to a Sharia law specialist to make sure that you put in place a will that will do that basically. So British law, so English and Welsh law, the way it works is if you're married and your estate is worth £322,000 or less, then everything automatically passes to the person you're married to, so to your surviving spouse. If the estate or your assets, so everything combined, so your house and your personal items and your jewellery, is worth over 322,000, it becomes slightly more complex. So £322,000 passes to your spouse. Everything on top of that is then split equally between your spouse and your children. So say you owned a property that was worth £400,000, not all of that would then pass to your spouse, depending on how you own the property. So there is some sort of technicalities, it does depend on how you own your home and things like that. But broadly speaking, £322,000 goes to the spouse. Everything on top of that is split equally, 50% to the spouse, 50% to your children in equal shares. So, and I've got an example of this. So if a husband died with £500,000 without a will, then the first £322,000 goes to his wife. The remaining £178,000 is then split between his wife and their 3 daughters, say. So this would mean that the wife would then get £322,000 plus 44,500, meaning a total of £366,500. The remaining balance then goes to the children, but it only goes to the children on reaching the age of 18. If you write a will as well, you can specify that it goes to your children when they're older. Because I know a lot of people think an 18-year-old getting access to money is sometimes a little bit scary because they're still young really at that stage. So lots of people say to me, I would want them to be able to inherit when they reach the age of 21 or 25, so say they've had a bit more life experience at that stage. So another example, if a husband dies after his wife and they have no children, then the situation is obviously very different. They're the last person to pass away within the immediate family units. So it goes in the following order. So the first person would be, it would go to parents if any of their parents are still living. If the parents aren't still living, it then goes to siblings. So if they've got 2 siblings and one of the siblings has passed away, then it would go to their children. So 50% would go to their children rather than to anybody else. It wouldn't all go to the surviving sibling. That also includes half siblings as well. Then it goes back up to grandparents. So if there's no siblings, it would then be grandparents who would inherit. If there are no grandparents, it then goes to uncles and aunties. Then if there are no uncles and aunties, it goes to cousins. And then ultimately, if there are no cousins left, that's when we're looking at it going to the crown, which is, I don't think lots of people would rather that not happen. They want to specify where it goes, really. And the big thing here I'd like to note is if you don't have a will, this process can become extremely expensive, because I've had experiences with estates where there's not been a will and there's not been any immediate family, and we've had to instruct tracing agents, so people to go out, genealogists to go and find local, people that are distantly related to this person. You then have to sift through records all over the country, sometimes internationally, and then you can end up with maybe a pot of £10,000 that needs to be split between about 50 people all over the world, and it just is so expensive. It's far easier to make sure you have something in place to avoid a situation like that. Every individual has £325,000, which is completely tax-free. So when you pass away, you don't have to pay tax on that amount. When you're married, that transfers between spouses. So when the second spouse passes away, you then have a band, we call it, of £650,000. I should note that anything that passes between spouses when is completely tax-free, so long as it's under 2 million. So that's not really affect most people. So most, as I said, most married couples will get £650,000. Yeah, if they pass away, so in succession, basically, so the second person would. If you're leaving a property to a descendant, so to a child or a grandchild, you get an additional nil rate band, which is an allowance of £175,000 that can be used only against your property. So if your property, so that also transfers between spouses. So potentially you're left up with up to £1 million, which is tax free, but that is dependent on you having a property that you pass to descendants. Also, your property has to be, you can only use your residential nil rate band against the value of your property. So if your property value is £200,000, then you won't get the £175,000 and the additional £175,000 for your spouse. You'll just get up to 200,000 basically. You can't use it for the rest of your assets, only for the house. Anything above the applicable threshold is taxed at 40%. So it's a big taxation. So the big thing really is when people have properties that are worth over £325,000, and then they've not been married or they don't have any children. Ultimately, you always have to sell the house because you have to pay quite an extensive, tax burden. Really, there are all sorts of insurances and you can do sort of payments in stages, but they add interest to it, so then it just ends up that you pay more tax basically. But broadly speaking, that's the tax the tax regime in the UK. So there are also a number of different types of wills that you can put in place. There are simple ones which just basically say I want everything to go to my spouse and then I want it to go to my children. Very simple. But then there are more complex types of wills where you can have a trust in a will. So a trust is a legal arrangement where somebody holds an asset for somebody else. So it might be that a parent is holding something for a child on reaching the age of 25. That's what we call a bare trust. These are more common trusts that we see in wills. So one of them is a discretionary will trust. So this offers quite a lot of flexibility and it puts your estate into a trust basically. They're very complex and they have lots of sort of tax implications, which I'm happy to touch on, but if you're thinking of doing a trust, you just need to get really specific legal advice. Some of the benefits of putting in place a discretionary will trust is if you don't know where you want your assets to go, you're giving the responsibilities to somebody else, so to a trustee. So they can assess the situation when you pass away or because they're struggling. So it offers a bit of flexibility really. Another common type of will trust we see is a life interest trust. So it gives somebody the ability it gives you the ability to allow someone to benefit from your assets in a restricted way whilst they're alive, but then when they pass, the asset then goes to somebody else. So we quite often see this when somebody wants to make sure that their children are the eventual beneficiaries of their estate, but they have a partner or a husband that they want to be able to live in their property that they own jointly whilst they're alive, basically. So it sort of is a way of sometimes protecting against people getting remarried and then passing on your assets to their, however they want to do that after they remarry, really. So that's one option. The other one, which we see and we do quite a lot of, is disabled persons trusts or vulnerable persons trusts. So it's a trust that can be set up for a disabled person. They have to be sort of in receipt of means tested benefits and they have to meet sort of qualification. But it has a special tax treatment and it can sort of help safeguard to make sure that people still receive their means tested benefits. So if they're on maybe like a universal credit or something like that, they can still get the universal credit entitlement whilst also receiving money from your estates as well. It's quite a popular one for people who have relatives that are dependent on them that are vulnerable. So I thought I'd touch again on sort of wills and foreign assets. So can your will in the UK cover assets that you have in a different country? The answer is yes, it can. But there are always specific inheritance laws in different countries. So a really common example is in France and Italy, they have these forced heirship rules, which means that you can't say, I don't want one of my children to inherit. It has to go to all of your children, basically. You can have a will for each country your assets are in, but you have to be... Hello? Can you still hear me if I speak?
Yes.
Yeah. Oh, okay. Oh my God. So you can have multiple wills, but you have to be really careful that they don't contradict each other. I think if you're going to look at getting more than one will, you probably want to get specialist advice and take that will in to the other solicitor, basically. If you're going to make a will that addresses assets that you own in other countries, I would say in general, take guidance from a specialist that's based in that country, because UK lawyers here won't necessarily have the understanding of the laws in every other country, really. So it's always best to speak to somebody in that country to get an idea of what their law is. So as I said, in general, UK law covers all assets across the world, but only insofar as it's in line with the law where you hold that asset, basically. Okay, so that's everything on wills. Last and power of attorney, what we touch on. So, last and power of attorney is a legal document that enables somebody else to manage your affairs. And it used to be called enduring power of attorney, but it's changed now. So this is slightly different because it relates to your assets during your lifetime. If you want to make a lasting power, so this is the exact same as a will. You have to be able to do what you're planning on doing, basically. So the rule is really don't leave it too late, just get everything in line now. So there are two different types of lasting power of attorney. There are property and affairs and health and care lasting power of attorney. So what you do is you appoint attorneys. So you appoint attorneys who are people that you trust, basically, to either manage your property and affairs and manage your health and care. A lot of the time it's used when people want to make sure that if they lose mental capacity, so if they end up in a situation of where they're unwell, somebody else can step in to help manage their affairs, basically. So you can get an LPA by going online, so you can do this online. I've got two examples at the back there if you want to have a look at them. But you can download the form online and you can also then submit it yourself. Again, you can get a solicitor involved, but quite often they charge quite a bit and you can do it yourself. I would only recommend getting a solicitor involved if it's going to be contentious in any way. So if you're saying, oh, I'll appoint this person, but I don't want this person to be involved at all, and you think they're going to argue, always get a solicitor involved, really. So the health and welfare one applies specifically to your health and your care. So if you're in hospital, it relates to any treatment that you have in hospital. If you're in a care home or if you're receiving care at home, obviously it relates to that sort of care as well. So your health and welfare LPA can only come into place and be used when somebody lacks capacity to make a decision themselves. So it's often when somebody's in a coma or if they've got a diagnosis of Alzheimer's or dementia that's quite far gone. Whilst you have capacity, you can provide your attorney with instructions. So you can say, on a day-to-day basis, I'd like to be looked after like this. And you can also give them the ability, the one thing is you can decide whether or not they have the ability to make a decision about life-sustaining treatments. So you can either leave it up to the doctors or you can make sure that your attorneys have that ability to make those decisions. Life-sustaining treatment can be anything from sort of surgery that's quite intrusive to just receiving antibiotics. So it's a massive scope of care. So it can be something like if somebody's needs a course of antibiotics in order to recover. And so the financial affairs one is a bit more flexible than health and welfare. And it can come into place as soon as it's registered. That's if you want it to come in place as soon as it's registered. So it means that your attorney, so whoever you choose, can assist you to pay and manage your financial affairs. And they can basically pay bills for you, they can sort out investments, they can arrange a property sale if needed. It's really important that you have in place LPAs for financial affairs and health and welfare. But with financial affairs specifically, if you're ever in a situation where your house needs to be sold to pay off the debts or to pay for care, if you don't have a lasting power of attorney, that's where Lauren steps in, and you have to go through the court of protection route, which is so much more expensive. We've had cases with the court of protection where if it becomes disputed, you're talking about £10,000 in legal fees. It's so much easier to get this sorted so that you don't have to worry down the line, basically. So, as I said, if you want to make an LPA, you can get the forms online. You just need sort of personal details of the attorneys that you want to appoint. But you also need a certificate provider. So this is somebody who's over the age of 18, who has known you for more than 2 years, or is a professional, so a doctor, a nurse or a solicitor, who is able to confirm that you understand what you're doing, basically. Yeah, so that's all you need really. Your certificate provider can't be an attorney, it shouldn't be related to an attorney, it has to be a completely independent person. It's usually a friend or a neighbour. So just to conclude, even if you don't think you have much to leave behind, it's always worth making a will. It sets everything out in black and white and it's fast. It will reduce family friction and emotional time, and it can help you with inheritance tax planning. It's also worth considering making a lasting power of attorney if you haven't done so already. As I said, these apply during your lifetime, but they're really important if you're ever in a position where you can't make a decision for yourself, basically. But yeah, that's everything. If anybody has any questions, just let me know. But I should say that the documents that I've passed around are the slides, so if there's anything that you're not certain of now and you think of later on, you can always give me a call or drop me over an email and I'll respond. Thank you.
Thank you. You know, if you have a property abroad and you need to sell it, and do you still have to pay tax?
It depends on, so is this selling a property when you've passed away?
Yeah, let's say one person passes away and it needs to be passed on. So if it's, let's say it's more than the threshold that you mentioned,
yeah.
So would you still have to pay tax even though the property was in somewhere else?
So the when you go to get the grant of probate, which is the document you need to deal with your estate, you will need to basically ascertain the value of your estate as a whole. So that will include your foreign assets, including property estates abroad. That will mean that when you submit that figure, you'll have to pay that tax. So you have to pay the tax before you submit the figure, basically. But there are ways of claiming it back if you pay tax abroad as well. Oh, sorry. If you pay tax abroad as well, because often you have to pay inheritance tax abroad, a different type of regime. You can go through a process where you sort of claim to HMRC that you've been doubly taxed, but it's quite long-winded. But I wouldn't be able to advise specifically, depending on where the property is. But when you submit an inheritance and tax account in the UK, you have to say the whole value of your estate.
Thank you.
No problem.
If it's in Pakistan, it's a different also.
Yeah, it's a different tax.
Yeah, because you might pay tax in Pakistan and then say, well, I pay tax here as well. And then you'd write to HMRC and say, look, this is the situation. Does that make a difference in terms of how much I paid in tax here?
Okay. Thank you.
No problem.
Keep hearing about putting your house in a trust rather than leaving it as its own. You could keep hearing about it, and then there won't be, it won't go into probate, and it goes, you'll have easy access to it, your dependents.
So sometimes it can work to mean that you don't have to go through probate, because if it's put into a trust, then essentially you no longer own it. It's owned by the trust.
So who's the trust? What's that?
So the trust is it's whoever you set up as your trustees, and then your beneficiaries might be you and your family. But what would happen is that property would then, the legal ownership of that property would be the trustees rather than yourself.
Okay.
So when it comes to putting your house into trust, you have to get really specific advice. A lot of people do it because they think it will avoid care fees, but in general, if the local authority think that you're deliberately disposing of your assets, you're deliberately putting them into a trust to avoid paying care home fees, they'll clock onto that and say, well, you're still living there, so you've still got a benefit.
That's what I was going to ask.
Yeah.
Is there a rule of that you shouldn't be living there?
Well, if you want to completely get it out of your estate, so if you don't want to own it at all and you don't want it to affect how much money you have in your estate, so for inheritance tax, you can't then live in that property and have that benefit, because it's what HMRC call a gift with a reservation of a benefit. And they'll say, well, if you continue to benefit from that house by living in it rent-free, then it's still technically yours, even if you've disposed of it, basically. So you've got to get really specific advice depending on your circumstances.
It keeps coming up everywhere.
I know.
Don't put, put your house in a trust.
I'm not saying that there aren't options and there aren't ways of doing it. It's just you've got to be very careful with the way you do it, and it's always not. There's never a guarantee that it will work. Basically.
What happens to money in the bank?
So your money in the bank, depending on how much you have, when you pass away, either the bank will require a grant of probate in order to access that money. If they don't, then they usually just release it to the executors, to the next of kin, and then the executors are responsible for distributing it in line with your will and your wishes.
One of the spouses dies. Does all the money go to the other?
Yes.
If it's a joint account.
If it's a joint account, then you needn't worry really. It automatically passes to the other person. It's called a right. It's a survivorship basically. So it goes by what we call the right of survivorship, which means that if the property or the bank account is jointly owned, then whoever is the joint owner of that asset gets it outright anyway. It passes automatically to them.
What if they both die?
If they both die, then we're looking at this. Depending on whether somebody has a will or not, it either goes to children by the intestacy rule, so if somebody doesn't have a will, or it goes in line with the will. So if you have a will that says, I want some of it to go to charity and I want some of it to go to my children, then it would be distributed in that way. But it will, in terms of planning your estate, they look at the full picture of everything. So it would include your house and your bank accounts and any debts. So you pay your debts first, then it would be the bank accounts and the houses that are distributed in line with your will. So whether you need probate is dependent on how much money you have in the bank account.
How much money is it?
Yeah, so it depends on the bank specifically. I would say that often they will release without the need for probate maybe about £10,000. Sometimes they will do, I think some banks will release up to £30,000, but I don't know whether they change that in the future basically. And also if there's any suggestion at all that they think it's going to be disputed or there's any sort of argument over the money in the bank, they will hold on to it until you get probate. They just will not release it.
I've heard that that's what they do. As soon as, and a lot of people withdraw the money before the bank.
This is it. You make sure if somebody does pass away and there's a bank account, you need to make sure that you get probate, because you can be criticised if you withdraw it without having the right authority, basically. Just make sure. What we do when we're administering estates is we do these, what we call like an estate account, which is basically we look at what everything was when somebody's passed away. We look at what the debts are, and we look at the funeral bill and things like that. And then it's the final figures that we then look at distributing. So you take all of the debts off, you make sure the debts are paid before you distribute anything to anybody else. But quite often people get solicitors involved for estate administrations because it's a lot of administration, it's a lot of admin. So, yeah.
So what if a couple, they may have some joint accounts and some in their own names as well?
Yeah.
So what happens to those accounts at their individual names?
So the accounts in their own names, this is where you probably need to either get a grant of probate to gain access to those accounts, or you write to the bank usually. So what we would do, if somebody's passed away with an account in just their own name, is I would then write out to the bank and I'd send them a copy of the death certificate, and I'd say, this is the situation, what is your procedure? Are you happy to release it to the person that's entitled to it now, or do you require a grant of probate to release that money? If they require a grant of probate, then there's not much else you can do. You have to then apply to the probate registry to get the grant of probate to be able to get access to that money.
So can the person not say to the bank before they've died or whatever that if I die, that's
No,
you can't?
I know, yeah. It is unfortunately not. You need to go through the legal procedure really. I know it can be quite frustrating really because ultimately, especially when it's spouses and your will says that, that's what you're going to want anyway, but you have to go through probate if they won't release otherwise.
I've heard that somewhere as well, that if you have any accounts in your own name, you should ask your bank that the beneficiary of that should be your partner. And if you say it beforehand.
I've not really heard of that before. I think if this is where your will comes into play really, and this is where the sort of the legal rules come into play in terms with the intestacy rules as well. So if a bank will just have their own procedure as to what they'll require depending on how much money is in that account for them.
Okay, that's a good idea to have all joint accounts.
Yeah. So I was just thinking, if you got just individual account and you're worried about with all this what's going to happen afterwards. So if you include another person like your son or daughter without giving them access to your account, can we not do that? And if let's say it becomes a joint account, but obviously while you're alive you're not letting them benefit from it. So after your death they will be able to just have it?
So if you do it as a joint account, but you still, so it does pass to them automatically if it's a joint account. But I would say that sometimes people can dispute that. So if there's another person involved, another child perhaps, that's not happy with the situation, it is possible for somebody to say, well, this other person never had access to the account, never deposited any money into the account, it shouldn't be viewed as a joint asset, basically. I'm not saying that would happen in most circumstances, but it is a possibility. The presumption is always, if you own an account jointly, that you're intending that to go to the other person when you pass away. But it is possible to argue that.
Yeah, thank you very much.
No problem.
What about your house? Can you add a child onto your house?
Yeah, well, so in terms of joint ownership, so there's two different ways of owning a property. One is owning it as joint tenants, which is similar with a joint bank account, where it passes to the other person by the right of survivorship, so it would pass automatically to that person. But there's another way, which is joint tenants in common, which means that you own like an earmarked share of that property. So you might both own 50% each if it's a husband and wife, but not own it jointly. So that's a slightly different situation, because then if you pass away, your 50% goes in line with your will or the rules of intestacy if you don't have a will. Rather than going automatically to the person that you own it with. If you wanted your property to pass automatically to a son or a daughter, then you can own it jointly. It's just it won't make a difference. It won't make a difference to your inheritance tax position at all. It's still calculated as part of your estate, half of the value of the property.
So where does that 7-year rule apply?
Yeah, I was going to ask.
Yeah, so good question. So the 7-year rule is if you dispose of an asset or if you make a gift during your lifetime that's substantial, then you have to survive it by 7 years in order for it to completely fall out of your estate for inheritance tax purposes. So,
So you have to live it out.
you have to live it out, basically.
Even if you still live in that place.
Yeah.
But I would say if you're still living in that place, we're coming back to the question of making a gift but reserving the benefits. So even if you make the gift of the house that you're living in, HMRC and the will clock on to the fact that you're still benefiting from that property, so it will still form part of your estate anyway. But if in terms of the 7-year rule, if you make a substantial gift, you have to survive it by 7 years for it to be out of your estate. But the moment you make that gift, the inheritance tax threshold gets tapered down. So I think if you survive it by 3 or 4 years, you're then looking
less and less.
exactly. So you're then looking at paying, instead of 40% inheritance tax, you're looking at 37, 36, 38%.
So gift is probably the best way, in some way, to reduce your inheritance tax.
Yeah.
It's probably the best way.
Yeah.
If you do it at an early stage of your life.
So you can actually give your house to your child or someone else.
Children.
Without
Can you do it to
yes,
more than
yes.
once?
So it's just a gift, no money in the
You're
bank.
doing your child a favour in the sense that if you live out the 7 years after gifting it, every year the tax will get less for the child. So the child is benefiting from that.
You're still reducing your tax.
But you sell your house to your child for a less amount as a value.
You probably end up in sort of difficult circumstances. I would say anything involving a property that you're living in, if you're looking at making a gift, it won't work in terms of reducing your inheritance tax threshold, because HMRC, they're very clocked on to the fact that people are trying to do this, and they'll say, well, you've been living in that property and not paid a market rate for
a lot, but now
things have changed. 100% it's changed. It's now we just I see it all the time now where exactly. I've had it before where people have said, oh, but actually my dad gave me half of that property, but he was living in there until he passed away. So you just can't, HMRC will say, well, then you own the whole thing. If you live there and you didn't pay rent to the other owner, then you've still got that benefit, really. So you've got to be really careful about any gifts that you make, particularly in relation to the property that you're living in.